Bear with me for a moment. I know you're there, but I'm technologically challenged. Okay, we have everyone here on this case. Mr. Herbert, I'm going to ask you if I pronounced your name correctly, as I went to law school in New Orleans and the quarterback was Bobby Hebert, number 3. So do I pronounce your name Hebert or Herbert?
It is indeed Herbert, Judge. Thank you.
Glad to have done it. I reveal my geographical predispositions. Did you wish to reserve any time for rebuttal, sir?
Yes, Your Honor. 5 minutes, please.
Okay, thank you. We can proceed. Please go ahead, counsel.
Thank you very much. May it please the court. Good morning. My name is Brendan Herbert, and I represent the appellant Bank of New York as trustee in this matter. This case derives from a contested residential foreclosure action in Hillsborough County, where after the borrowers appealed the final judgment of foreclosure, this court reversed, finding a lack of standing at inception of the lawsuit.
Would you concede that the bank was the holder of the note at the time of trial?
No, Your Honor. I think that the record was clear, and I think this court actually found that there was no evidence before the court that the bank held the note at the time of trial. And that's, in fact, why this court reversed the lower court's entry of a final judgment of foreclosure.
At the time of inception or the time of trial?
At the time of inception. At the time of trial.
At the time of trial, was the bank the holder of the note?
Yes, Your Honor. There is record evidence to show that it held the note at the time of trial.
Now, I can understand how some of the other DCAs would still find that fees should not be forthcoming, because the rationale is that challenge standing at any point, or at least could be maybe inferred from those cases, that you don't get fees under the reciprocity statute. But under prevailing case law here, Harris, would that not constitute evidence of a contractual relationship, the fact that the bank established at the time of trial that they held the note?
I think that Harris is, and that's certainly the case that the appellee does cite in their response brief. I'm well aware of Harris, and I'm also well aware of Hobson, which we filed recently as supplemental authority.
Well, I think we have the author of Hobson with us, don't we?
We do. Yes. We do.
My question is this. My understanding is, and just to distinguish the cases, it's easier for me to name the author of the author of the opinion. Judge Sleet's opinion appears to be binding in this district right now, and I understand oral arguments are set for that case. I'm going to try today, September 11th. Is that correct?
Yes, Your Honor, that's correct.
Right. So right now, Judge Sleet's opinion, I would suggest, doesn't it govern this disposition here?
Well, Your Honor, I think that there's a distinction with a significant difference between this case and Harris. And I think that distinction, and what we also ask for is, just so Your Honor knows, and we'll be asking this at the conclusion, to the extent that this court determines that Harris is in fact applicable, we would ask for a stay or to certify conflict, as the court did in Harris with Glass and Fitzgerald from the 4th and the 3rd District Courts of Appeal, respectively. The difference, though, with Harris is that in Harris, I think that this court acknowledged that there was, in fact, an assignment of mortgage, which was record evidence, which predated the filing of the complaint. The Harris complaint was filed in 2014. The record evidence in that case showed that there was an assignment of mortgage that assigned the note and the mortgage sufficient to create privity between the parties 2 years prior, in 2012. The trustee, or the Bank of New York as trustee, submits that Hobson is more analogous to this case. In Hobson, the borrower in that case impugned the integrity or the enforceability of the assignment of mortgage, just like the Stromingers did here. They fought tooth and nail throughout the litigation, just as they did here. And there was actually a finding, both in Hobson and in this case, that the assignment of mortgage, which the foreclosing entity used to try to prove up their standing, was fraudulent. That was argued by the Stromingers, and this court in the appeal of the final judgment of foreclosure specifically acknowledged that.
Well, Judge Pendino entered an order saying it was fraudulent, right, and dismissed the case.
That's right.
Okay, and
That's
then
right.
later on, he reinstated it because he thought arguably the statute of limitations might have run. Probably the new decision that says every lack of payment creates a new wasn't on board at that time. But anyway,
That's
there
correct.
is a finding that there was a fraudulent document here, right?
That's right. That's right. And the reason that there was a finding that there was a fraudulent document was because this case was filed in November of 2007. In the notary expired in 2012. Notary is only good for 4 years. And so the argument that was advanced by the Stromingers and accepted by the trial court was that that assignment of mortgage could not have been created prior to the filing of this lawsuit. In fact, yes.
Herbert, was that same assignment of mortgage offered in the second trial?
It was, Your Honor.
Okay.
It was. It was.
So that was advanced again by the lender in the second trial, even though the court had found it to be fraudulent in the first.
Yes, Your Honor. I don't.
It's that assignment of mortgage that ties this all in, that there's a contractual relationship. Is that right?
Well, Your Honor, I think that there's that
Well,
is.
let me ask it this way. Let me ask it a better question.
Yes.
If the assignment of mortgage was not fraudulent and it was offered and admitted into evidence, then you would have to agree that a contractual relationship was established below.
Well, I would agree that Harris would control.
Okay.
I certainly. I think that the reasoning in Harris that just the creation of the assignment of mortgage creates privity between the parties. I don't agree with that. Just because a mortgage follows a note in Florida, so in able to enforce a mortgage even with an assignment, you have to show that you're a holder at the inception of a foreclosure lawsuit. But
here we don't have that issue. I mean, the note, the lender was the holder of the note at the time of the trial.
That was what they alleged, but there's nothing on the record. And additionally, the Stromingers actually contested that issue, and they prevailed on that.
They prevailed at the time of inception, but not at the time of trial.
At the time of inception, but not the time of trial.
They prevailed on standing. Yeah.
That's right. That's right.
So technically speaking, at the time Judge Pendino entered his order, your client could have taken a voluntary dismissal and refiled and would have been the holder in possession at the inception of the case.
They could have done that, and they could have, assuming that they actually held the note, and they were a holder under 673. They certainly would have. Yes, they could have refiled.
They elected to continue this action.
They did. They did.
Part of my concern with this, and I know what the fourth has said, no standing equals no attorney fees. But at some point, some of us grew up in the notion that the resources of trial judges are limited. And if we take that view, when you start bringing in counsel who's unprepared, doesn't know how to prove the case, forcing somebody else to have to defend it, why shouldn't they have to pay attorney fees under the reciprocity provision? I know judicial estoppel doesn't work because they didn't successfully prevail on that theory, but they're arguing, hey, we're good. And they can just keep on bringing them and keep on bringing, poor cases in front of the trial court, causing somebody to have to incur attorney fees.
Well, yes, Your Honor, and I understand that. I mean, I do.
Well, wouldn't the rule encourage them to prepare their case if they knew they might be responsible?
I think it's certainly. I think that is absolutely correct.
I guess I'm tipping my hand that I was a trial judge for a while.
Absolutely, and I understand that, and I get cases like that all the time escalated to me, and I understand that, and so I see it on a daily basis. I used to see it more often. I think it's gotten a little bit better, but I do see that.
I think you're right.
Right. And so, but I think that what we go back to here is that there's two things. I think from the inequity standpoint, and I think that that's one of the issues that this court had in the Harris opinion. It did specifically talk about just that. Is it equitable to not allow a party to utilize the benefit of 57105 subsection 7 when they are hailed into court? And I think that there's two answers to that. Number one, they do have a basis. If there's a frivolous lawsuit, Your Honor, they certainly can utilize other portions of 57105.
Right.
They can certainly do that. And so they are not completely lost. If there is a case such as this one, where a borrower believes that there is some sort of fraudulent evidence right from the beginning, which is what the Stromingers did argue almost from the inception of this lawsuit, they certainly could have served the plaintiff with a safe harbor provision and then pursued fees under a different portion of 57105.
However, this section 7 is basically one to equal bargaining positions somewhat in the original instrument. This is not a sanction for frivolous.
That's right. And so as part of that, what this court acknowledged in both Harris and Hobson, and other courts routinely have as well, is for a party to utilize the benefit of subsection 7 of this specific section, they have to prove 3 elements. Number one, that there was a contract with a one-way fee provision. The Stromingers have done that here. Number 2, that there was privity between the parties. And we submit that the Stromingers have not done that here. There was no record evidence that from the
can I stop you there? Because
Yes.
that's of interest to me, whether there's record evidence. Because this goes to some of the arguments you made about the burden and about, if I don't want to mischaracterize what you said about pleading, so to speak. In other words, allegations in the motion. In other words, what your position, bank's position is what was alleged in the motion and what was evidence argued in the motion matters. But under Harris, which we're bound to follow, that they said, this court said, because record evidence established there was a contractual relationship. But would you not say it's clear from Harris that it doesn't matter what was pled in the motion? It doesn't matter what evidence was invoked or referenced in the motion. If there is that record evidence established, there was a contractual relationship, then the court can award fees.
Right. And so, Your Honor, I don't think, I agree with you, but I do not think that there is any evidence that as to
my next question then, so
right.
you agree that, I'm sure you don't agree with that proposition from Harris, but
Right.
that's what Harris said. But it is, I have 2 questions then. One about the assignment. You are relying on the fact that the court found that it was fraudulent. Let me ask you this though, is it important that it was fraudulent only as to the date? In other words, it was backdated, but does that mean that there was never actually an agreement that was entered into? The assignment wasn't valid at all?
Well, I think that it would be valid with respect to the assignor and the assignee, certainly. But I think that for purposes
so
of
doesn't that mean the bank stands in the shoes of the assignor?
Well,
it was valid. You just said it was valid as to the assignor and the assignee.
Right.
So doesn't that mean if it's valid for that purpose, then that the bank stands in the shoes of the assignor?
Well, I think that there is the distinction here, though. However, and I know that is maybe not the right answer that you want to hear, but I think the importantly though with Harris, that lawsuit was filed in 2014, and the court acknowledged that there was an assignment in 2012, which predated the filing of that lawsuit. Here, the court found that there could not have been an assignment created prior to the initiation of the foreclosure being filed because of the date of the notary and the expiration.
I guess this is the concept. The concept applies equal to the note and the mortgage, both of which included a fee provision that the appellee could rely on as far as reciprocity. Is this the chronological issue? And I've thought of this before, and I'm curious about your take, which is if standing was only impugned as to the time of inception, yet there was, and if we rely on Harris, which we were bound to do, evidence established that there was a contractual relationship at the time, at some subsequent time, or that either by the assignment, which you agree was valid for the purpose of the 2 parties who were parties to the assignment, and as to the note, for which there was evidence that the bank was a party at the time of trial, does that not comply with Harris, which requires this court to credit any evidence that's in the record for the purpose of affirming a fee judgment?
Well, I think that obviously standing to enforce loan documents is required at inception. That's something that you can't correct. And so if a party does not have standing at inception, that can't be cured down the road. Now,
that is time machine.
Exactly. And so if the Stromingers prevailed, which they did, on the notion that the Bank of New York did not have the ability to enforce the contract when at inception, which it is required to prove up to be able to foreclose on a mortgage in the state of Florida, then that can never be corrected. Now, I understand your point about, well, what happens when there's some evidence down the road that there is contractual privity? And that's interesting, because that's I would submit then, and we argued this at the fee hearing as well, is that then because the burden is incumbent upon the parties seeking fees under 57-1057 to show the existence of privity, and we know that Harris says that, Hobson says it as well, then the record evidence would show a date certain wherein the parties were in contractual privity. If a party shows up to trial with the original note, and that's the first indication or first evidence that the parties were ever in privity, then perhaps that is sufficient record evidence to show that that is when the fees under 57-105 subsection 7 start to accrue, and where a party starts to be entitled to them.
Mr. Herbert,
Yes.
The assignment of mortgage, because the notary, the date is wrong. It doesn't necessarily matter, I guess, for if looking at the contractual relationship here, is it either was entered before or after the court found that it was fraudulent and it couldn't have been entered prior to the lawsuit. But at the time of trial, it appears that obviously there was some sort of assignment, whether it be defective for the notary or not, that the lender here would stand in the shoes of the assigner. So how does that not then make Harris that we have to follow our precedent here in Harris?
Well, I think that
Counsel, you should be quick because we have passed the 15-minute mark.
Yes, Your Honor. Thank you very much. Your Honor, I think that what's important about this one is that there was the court did not give credence to that assignment of mortgage. There was no value. That this court determined that it was fraudulent. The Stromingers took that position. That didn't happen in Harris. In Harris, there was an assignment, and this court actually said in Harris that Harris, the borrower in that case, acknowledged the contract between the parties and just argued that there was a standing issue. That's not what happened here. The Stromingers at every turn in this lawsuit, in their pleadings and their motions at trial and in this appeal, completely disavowed time and time again at every juncture any privity between them and Bank of New York is sufficient for Bank of New York to enforce the contract against them. I know that my time is up.
Thank you, counsel. I'll do what I can to give you close to 5.
Thank you.
Let me turn to Mr. Biasotti.
Good morning, Your Honors, and may it please the court. I'm Robert Biasotti, representing Lawrence and Adriana Strominger. The arguments that have been made here would have been great arguments when we did the first appeal in 2015.
I think I was there.
You were there. As a matter of fact, it was on the second floor courtroom, if you recall.
I do.
So, Harris, which wasn't the law there, but the trial judge lined with Harris. All of these arguments were interesting, and we won. We prevailed on the appeal. We got an award of attorney's fees from this court, where this court awarded attorney's fees based on 57-1057 and the mortgage contract. So all of these arguments regarding Hobson and Harris and other cases are on the merits, but the merits were decided in 2015. We are only here on whether the trial court should award attorney's fees. They awarded appellate fees consistent with this court's order. So the only issue, I think, at the time that this was brought up, this appeal was brought up, is whether there was sufficient notice for the trial court. And we certainly brought up in our answer brief, I guess, 2 things that maybe have been overlooked. One is law of the case. This is one of the few cases I've been involved in where there actually is law of the case. where the appellate court actually ruled on this issue, sent it back to the trial judge, and the trial judge affirmed fees based on this court's ruling on her appeal.
On appellate fees.
Sorry?
On appellate fees for that appeal.
Yeah, I want to be clear that the ones that they cite in their reply brief, two cases having to do with fees. And the fees have to do with 57-105-1, not 57-105-7. And the whole concept of law of the case is whether the legal issues were addressed and raised at the appellate court. No question that it was raised. Was there a contract? Did it exist? Did the reciprocal version of 57-105 was invoked by those contracts? And the answer to that was yes, by an order from this court issued in 2016.
And Mr. Biasotti, the motion for fees that was brought in that case was under subsection 7. No response to the motion was filed, correct?
Yes.
And no rehearing was sought after fees were granted.
Correct. I mean, that's kind of it. You're arguing about fees. I think Mr. Herbert, and I know I've been in this position, he wasn't the appellate counsel for the last time around. I was the appellate counsel for the last time around. We argued this, and in fact, we lost in the trial court originally, and this court reinstated it, and we prevailed. So all of these issues about Hobson and Harris really have no effect in this case, because this case was decided in 2015.
But let's assume that we draw a distinction between the appellate fees in that case and trial fees, and which is the subject of appeal for the purpose of law of the case, and move to the meat of the argument about the 57-105-7 statute. Now, I described when I was discussing it with opposing counsel a way to infer from the Harris decision that any evidence in the record whatsoever can be relied on by the trial court or the appellate court when reviewing the fee order, which is probably what happened in Harris. But that's not the only thing to infer from that case. That case could have been just making reference to evidence that corresponded to the arguments made by the moving party. Shouldn't it matter whether the party moving for fees actually takes a position in its motion and in the arguments at the trial court that there is a contract, point to the rationale for contractual privity, or a movement having not done so, it's irrelevant to us when we review the order on appeal?
It's a good question, Your Honor, and let me be clear about this. When this came up in 2016, those arguments were made and we prevailed on that. At this point of the case, and let me distinguish this between Hobson, which you wrote and I was a part of, and this case. In Hobson, there was complaints and there was challenges to the power of attorney and other things. In this case, there was zero evidence of that. We put on no evidence. We didn't cross-examine one witness. The only issue had to do with the date. They were trying to post-date a document based on a notary. That doesn't make the document invalid. That doesn't mean there wasn't a contract between the Stromingers and Bank of New York. That was an undisputed fact. They put in this evidence. They put in the contract. They put in 16 exhibits. And without putting on any evidence or anything, we moved for a judgment in our favor. They opened the case again. They put on additional evidence. Again, we put on no evidence. We didn't challenge anything. The only thing that was in there was the note and the mortgage that they put in there without any response from us. And the whole concept of Harris is the difference between standing, which is standing in the initiation, and standing at trial. I think they admit there was standing at trial. I mean, they put on the evidence. It wasn't disputed. There was no contrary evidence. the note and the mortgage were existed. Was there evidence or standing at inception? This court found in Strominger versus Bank of New York 2015 case that they did not have standing at inception, and that's why they granted fees. So
Now, this goes to, I
That-
think,
That opinion, if I recall from Judge Crenshaw's authorship, said they didn't put in competent evidence to prove it. Is that correct?
correct.
So they didn't say that the documents were invalid. They just said, based on the authenticity and the failure, that evidence was not sufficient to carry your burden of persuasion.
Correct. That's correct. But I
Leaving open the question is if they brought in someone to testify to fill in the blank, so to speak, there might have been a different outcome. Not necessarily, but based on the record then before the panel.
Yeah, this is a highly unusual case because, as you point out, Judge Pandino did dismiss this case based on a particular document that was wrong. And 3 years later, we get to trial and they move that document into evidence after telling the court that they would never do that, and they did it. Now, again, a different trial attorney. There were 3 or 4 different trial attorneys representing Bank of New York in this case. But that is, I believe that's the law of the case. Counsel, Mr. Herbert also mentioned, if you look at the record on what was argued on entitlement, the transcript for entitlement is not in this record. It's a transcript on November 11th, I think it is. And on that date, where there's no transcript, the court ruled that there was entitlement for appellate fees and not entitlement for trial fees. And she asked the parties to do the law as to why there shouldn't be entitlement for trials fees. They did it. They did the memos of law. The court read it. And the court found that trial fees should be granted. This is, I think Judge Casanova wrote it. This is a 2007 case. And we prevailed on the case 5 years ago. And we're still fussing over attorney's fees when I believe law of the case means that issue was resolved 5 years ago. But the other issue we have is we did not argue, and there's nothing in this record that says that we challenge this at every level. We did challenge the note, the notary, not the note, the notary. But the note and the document and the assignment of mortgage and the mortgage were all entered into evidence without objection. And that's certainly valid evidence to support an award of fees. This court found that to be the case. The trial court found it to be the case. And now they're challenging that. So
the going back to my question about pleading, for lack of a better term, and I think this goes to one of at least the rationales of some of the other DCAs, which is that a foreclosure defendant can challenge standing, essentially challenge the privity of contract all the way up until they move for fees, and still by tacitly by silence have the position that there was never any privity of contract, and yet be awarded fees without having in their motion. And I know we don't have a transcript, but or at a fee hearing, adduce a rationale based on evidence of privity of contract. So my question was, even under Harris, isn't it incumbent upon a movement to actually point out the evidence that they're relying on for privity of contract?
I think the answer is no. And I think the whole point of this is this case at that time when there was a hearing, this case had been going on for 12 years, and it was all about foreclosure of a mortgage and note. They're the plaintiff. I mean, they put in the evidence. We didn't dispute it. I mean, it was undisputed evidence that they put in that we didn't challenge, that we put on not only experts, but no evidence. So I don't think that a party has to say, we're relying on the note and mortgage that they put into evidence, and nobody objected to. And if we don't say those magic words, we're denied fees. Certainly wasn't the case at the appellate level. It's sort of incumbent. The trial judge who tried the case knew the evidence, was aware of the evidence, was aware that they put it into evidence. Do you have to say the magic words? Well, they put in the note in the mortgage. We're relying on that. I mean,
The trial judge first granted the motion for involuntary dismissal and then receded from that. Is that correct?
Yeah, what he did was, this is Judge Pandino did that years earlier. He did recede for it. He did let the case go on. They said they would not rely on that document.
Judge Taylor entered an order denying the motion for involuntary dismissal, I think after first putting in a final of judgment of dismissal that she vacated it and then first granted it, vacated it, and then said denied. Is that right? And that's how you got to see us the first time?
Yes, sir.
Okay. Deja vu all over again.
Not that it matters, but we also got a stay, an emergency stay.
Okay.
Mr. Biasotti, why shouldn't we hang on to this until the Supreme Court decides, in their estimation, who's right and wrong about who's entitled to fees under 57-1057?
Yeah, I think that would be absolutely wrong in this case because those arguments were not preserved in 2015. The issue was at that time and still is ruled on in 2015. Are you going to go?
You're
back?
saying because of the law of the case?
Yes.
All right. Any other reason besides the fact that you believe this issue was decided in this case in the previous appeal and it's been around for a while? Any other reason?
I think it's really inequitable to the attorneys on this case, but if you want
unless it ends up your client's not entitled to it according to the Supreme Court, then it wouldn't seem as inequitable, but we don't know that until they decide.
Yeah, it's look, this case started in 2007. It's 2020. David Thorpe, who's been the trial attorney for 13 years, hasn't been paid a penny. He got a judgment for $35,000 for 10 years worth of trial work, which Bank of New York never even bonded. I mean, it's just crazy. You know, attorneys, they take on clients and they try to put their best foot forward. We won the case.
It has an inequitable ring to it, but would it seem inequitable if next month the Supreme Court decides that someone in your client's shoes is not entitled to fees under 57-1057?
Does this court go back and undo every attorney's fee award on 57-1057 for the last 13 years? Case has been decided. There's supposed to be law of the case. We're supposed to rely on the decisions of this court. You don't get to now. Are you going to undo the attorney's fees award for the appellate fees? I have to return my money to you for winning the last appeal 5 years ago. I think that would be wrong. And this is not that kind of a case. If we were here arguing the merits of the case, I would agree with you. We argued the merit case 5 years ago. And for them to stretch this out for 5 years and wait till, and Harris, I guess Harris isn't directly up there, but it'll be decided maybe. I mean, they asked this case to be stayed several years ago based on Glass, and Glass was never decided. So I don't think this court should wait for the Supreme Court to decide a case which they may or may not decide in the next, 5 years. Anyway, thank you. I appreciate it.
Thank you, counsel. Before we go to the rebuttal argument, I noted yesterday that Judge Sleet's opinion still doesn't have a Westlaw reporter site. So I try to set some wheels in motion that will correct that. So if you see a Westlaw site coming out, you can know this case was the prompting of that.
Judge, you should know I've called Westlaw several times and I've called the clerk of the court about that. I don't know what's the mandate was issued in 2019. Yeah,
it's been a while. That's what prompted me to go in case there was some rehearing motion that hadn't been heard. I was a little concerned about, and it's sitting up in the Supreme Court and it says on it, it's not final until time for did I miss something? So I was a little concerned. So I made some discreet inquiries. Maybe this time we will actually persuade Wes to give it a citation. With that, Mr. Herbert, we are ready to go for your rebuttal.
Thank
And
you,
I'll
Your
let you know when you hit 5 minutes.
Thank you, Your Honor. I'd like to address the law of the case argument that Mr. Biasotti raises. First of all, the law of the case requires that questions of law actually decided on appeal must govern the case prospectively in the same court, right? We all know that. Now, this was an unopposed motion for entitlement to fees that was, I suppose, summarily granted. There's nothing before the court right now to show that this tangential issue, whether or not appellate fees were appropriately awarded on an unopposed motion, there's nothing to show that this court substantively addressed whether or not the moving party, the Stravengers, satisfied their burden. That burden well, first of all, the two cases that we cite, Labby versus Harrington and McNamara versus the city of Lake Worth from the 3rd and 4th District Courts of Appeal, those do address different sections of 57105, but they're the only cases that talk about whether or not under 57105, whether an appellate court's determination as to an award of appellate fees is law of the case on a trial court's decision. Both of those cases say that they're not. So that we do not.
Before you go ahead, Mr. Judge Atkinson. You were speaking first.
No. Well, I was just going to ask if can we infer from the previous appeal that there was a decision on contractual privity?
Well, I think we can, and I think that there was no contractual privity.
Because this court, but the purpose of the award of fees, according to Mr. Biasotti, is something from which we can infer a tacit decision about contractual privity, at least.
I think that we could also infer, Your Honor, that there was summarily awarded because it was unopposed as well. There's nothing.
Mr. Herbert, you are saying that this court saw a motion for fees under the subsection that had the contractual fees for the mutuality of fees, and that this court would have granted it just because there was no response?
Excuse me, Your Honor. Your Honor, I don't know the answer to that. And I think that
I think granting the motion under the subsection, let's assume that the court heard it on its merits and granted it, okay? And so I guess the question then becomes, okay, what do we do with a decision that was decided before Harris? And so Harris comes along. How does Harris change the makeup of this case where entitlement, as argued by Mr. Biasotti, was made that preceded Harris? And this case has been tracking along, okay, before Harris was decided. So I think that's really the issue that I'm kind of grappling with, is how does Harris change? Can Harris change the makeup of that entitlement that this court already determined on appellate fees?
Your Honor, I don't necessarily think that it can, but it can have a bearing directly on whether or not the entitlement to trial level fees was appropriate. If the court were to consider this law of the case, what it essentially does is it would be issuing an opinion that right around the same time it entered an opinion holding that there was no standing for the bank to.
So then what you're saying is, because the appellate fees was the issue before this court that preceded Harris, that because the issue of entitlement as to trial fees hadn't been determined yet, and just unfortunately for the claim for the borrowers here, that Harris came along and entitlement was decided after.
Yes, Your Honor. I think that's correct. So I think that makes a difference with respect to the entitlement of trial level fees. If the court finds that this is law of the case, then it would have issued an opinion saying that Bank of New York could not enforce the loan documents against the Stravengers, but then also a binding order that was law of the case saying that the Stravengers can enforce the loan documents against the Bank of New York. That would be inherently contradictory. With respect to the.
Before you go off to this point, let me interpose a question before I lose my track. Assume for the purpose of my question that your position may prevail or does prevail. There is a motion to tax attorney fees and costs that was filed between the two Judge Pendino orders. That one has not been ruled upon based on the fraudulent document. Would we need to, assuming that you're correct, refer back for the assessment of fees from the beginning of the case until that moment in time where the motion was filed, which I think is record 211?
Your Honor, I'm not sure that I follow your question.
Well, they filed a motion to tax fees based on a dismissal for putting in a fraudulent document. There's been no ruling on that motion. It appears it was subsumed with the final order. So assume that you're right on Harris or the other two opinions that somehow they would grant you relief. How would it preclude an award for damages, for attorney fees up to the moment in time where that motion was filed?
Well, Your Honor, I think that it would be left to the trial court's inherent authority to make that ruling.
It is. In other words, we reverse it back for hearing on that motion.
And Your Honor, again,
and maybe for an assessment of fees based on the hourly rate and such. I guess I'm concerned that
right.
If we accept your position, your C2 argument, it washes away all the attorney fees. And my concern is there's a legitimate motion that was never ruled upon following the dismissal of the first case by Judge Pendino and filed after that before the second order reinstating. Why wouldn't they be entitled to have that one heard?
I think that they would, Your Honor, and I think that that's, and I think
then we're on the same page there.
Yes, Your Honor, and I think
then I'll let you go back to your argument. I just want to make sure before I lost that one.
Right, sure, and I think that that's important. That demonstrates the interplay of burden. I think that the court previously mentioned, and is it the burden of the party that's using this specific section 57-105 subsection 7 to plead and prove its elements? The three elements that this court found are requisite in both Harris and Hobson. They didn't do that here. There's no argument, there's nothing on the record where the Strominger said, we are party to the contract between Bank of New York and us. This is when this contract was formed between us, and this is what we're seeking to enforce. There was a general 57-105 subsection 7 motion that did not address that specifically. They did not plead and prove that context. Now,
I think you may need to, I let you answer my question because I was consuming the last of your moments. But we're at 7.5 now, so I think I have to apply the time clock here so that there is no section that I'm going to let everybody one side run on.
Very well, Your Honor. I
appreciate both of your arguments. Thank you much. I think I speak for the panel for bearing with us and really navigating this continuing saga, if you will. And I guess, Mr. Herbert, we can welcome you to this case. Mr. Biasiotti and I have been on, I was on the first appeal, as you saw from the opinion Judge Crenshaw wrote. So we welcome you.
Thank you, Your Honor. Appreciate it. Have a good day.
And I welcome the new judges as well to this case.
Welcome.
Thank you very much. And we'll move on to our last case today.
Thank you.